Welcome to our discussion on the law on sales. In this first chapter, we will explore the nature and form of the contract of sale. The contract of sale is one of the most common and fundamental agreements in both civil and commercial transactions. Whether it involves simple everyday purchases or large-scale commercial dealings, sales contracts are deeply embedded in our legal and economic systems. Understanding its nature, requisites, and legal effects is therefore not only essential for academic study, but also critical for practical application in future professional practice. This chapter lays the foundation for appreciating how ownership is transferred, how obligations arise between parties, and how sales differ from other types of contracts. Let us now begin by examining the core legal basis found in Article 1458 of the Civil Code, which defines the contract of sale. Before we proceed with the details, let me present the outline of our discussion for this session. We will begin by understanding the concept of a contract of sale, where we define it under Article 1458 of the Civil Code and highlight its essence in law and practice. Next, we will examine the characteristics of a contract of sale, which distinguish it from other contracts such as donation or barter. From there, we will identify the essential requisites: consent, determinate subject matter, and price certain in money or its equivalent, all of which must be present for a sale to be valid. After that, we will look at the natural and accidental elements of a contract of sale. Finally, we will discuss the two kinds of contract of sale. This outline will serve as our roadmap for today's lecture, ensuring we move step by step from definition, to requisites, to the practical implications of contracts of sale in Philippine law. A contract of sale is a consensual agreement where one party, the seller or vendor, binds himself to transfer ownership of and deliver a determinate thing, and the other party, the buyer or vendee, binds himself to pay a price certain in money or its equivalent. Article 1458 of the Civil Code provides, by the contract of sale one of the contracting parties obligates himself to transfer the ownership of and to deliver a determinate thing, and the other to pay therefore a price certain in money or its equivalent. A contract of sale may be absolute or conditional. This means that the essence of a sale is the exchange of a thing for a price. The seller must deliver and transfer ownership, while the buyer must pay the agreed price. The contract of sale is a principal mode of transferring ownership in Philippine law, and is foundational in both property and commercial transactions. A contract of sale has 5 defining characteristics: consensual, perfected by mere agreement; bilateral, both parties have reciprocal obligations; onerous, each gives something of value; commutative, the values exchanged are intended to be equivalent; nominate, specifically named and regulated by law. In the case of Province of Cebu versus Galvez, the Supreme Court reiterated, a contract of sale is a consensual contract and is perfected at the moment there is a meeting of minds upon the thing which is the object of the contract and upon the price. For example, if Joe agrees to sell his car to Bill for 500,000 pesos, and B agrees, the contract is already perfected, even before the car or the payment changes hands. For a contract of sale to be valid, 3 essential requisites must be present. 1. Consent, a valid meeting of the minds. 2. Determinate subject matter, the thing must be certain or determinable. 3. Price certain in money or its equivalent. The Supreme Court, in many cases, has consistently affirmed these as the essential elements of a contract of sale. If any element is absent, for example, there was no agreement on price, then no valid contract of sale exists. Contracts of sale also consist of natural and accidental elements. Natural elements are presumed by law to exist unless excluded, such as warranties against hidden defects and the obligation to deliver. Accidental elements are those that the parties may stipulate, modify, or exclude, such as conditions, terms, or special agreements. For example, if the parties agree that ownership remains with the seller until full payment, this is an accidental element that alters the usual legal effect of delivery. Finally, Article 1458 recognizes 2 kinds of sale. Absolute sale, ownership passes to the buyer upon delivery. Conditional sale, ownership transfers only upon fulfillment of a condition, usually full payment. In the recent case of Estepona versus Estate of Aquino, the Supreme Court explained that in an absolute sale, title passes upon delivery. In a conditional sale, ownership remains with the vendor until the agreed condition is satisfied. Example, in an absolute sale, Joe sells land to Bill. Upon delivery, Bill becomes owner. In a conditional sale, Joe sells land to Bill, but ownership transfers only once Bill pays in full. To summarize, the key terms to remember: vendor, vendee, or seller, buyer, consensual, determinate thing, and price certain. It is a common error to confuse a contract of sale with a contract to sell, and assume that a written document is always necessary. Remember, a contract of sale is perfected by consent alone, though writing may be required for enforceability under the statute of frauds.